Welcome to this series of modules made up of video tutorials which focus on legal writing. Legal writing is an essential skill for solicitors and one which you will be tested on in the solicitor's examination and be using on a daily basis. The tutorials cover a range of topics which form part of the legal writing module, but you may also find it helpful to apply the principles covered by these tutorials when you write attendance notes, in the client interviewing and the legal drafting assessments. The focus here is purely on trying to help you improve your legal writing skills within a legal context, rather than focusing on the law. We are going to be considering why, who, the purpose of your writing, and the audience, the reader. We're going to think about plain English, being concise, legal jargon, the active voice as opposed to the passive voice, grammar, punctuation and spelling. Too often mistakes in these areas make writing look sloppy and gives a bad impression. It can also lead to ambiguities and misunderstandings. We're going to look at references to gender in your writing. We're going to think about numbers. So do you write a figure or do you spell out the number as a word? We'll look at citations. How do you refer to statutes, cases and other sources in your writing? I'm then going to look at some specific types of writing. There are many types of legal writing, but the ones which we are going to concentrate on are letters. I'm going to look at these in some detail, including client care letters. And then we're going to have a look at emails, attendance notes, and finally, memos. 2 important questions. Before you begin to write, there are 2 important questions to consider. 1, why am I writing? And 2, who am I writing to? If we take each of these in turn, why am I writing means what is the purpose? What's the reason for writing? So, are you writing to give advice, to convey some information, or to persuade or negotiate? As to the second question, who am I writing to? You'll need to vary your tone, your language and style depending on the reader. For example, a summary of a particular piece of legal research is likely to be very different depending on whether you're writing it for your supervising partner, for example, or sending a note to a client. If you're writing to the partner, then the note is more likely to include detailed references to your sources, including case law. You can probably assume an understanding of the relevant legal concepts. But you might not be able to make this assumption if you're writing to a client. You may need to explain the legal concepts to them. But of course, it all depends on your client. Some clients are very sophisticated and will grasp the issues involved easily. Other things you need to think about include how well you know the person you're writing to. You may be on first-name terms with a long-standing client, but will probably be more formal with a new client. Think about your relationship with the reader generally. For example, in the context of litigation, are you writing to a helpful witness or to a lawyer who represents the other side? Think about the reader's grasp of English, particularly if English is not their first language. Consider context. So if you're writing to a client whose spouse has just died, then you're going to need to be sensitive as well as professional. You may be writing to a regulatory authority or to the court, and the very nature of the body whom you're addressing requires a certain formality. So these are just some examples to highlight the importance of thinking at the outset about why you are writing and who you are writing to.